Morning, Brother Nasima. Are you online?
Good morning.
Brother Nasima is joining us online.
Yes. Morning, Chief.
Good morning. Good morning.
I sent that note
Yes.
been shared, placing on record the culmination of the consultative process. I also placed on record the proposed amendments and things like that. Since Mukund came in the context whether an endorsement would be required or not. So all this, the conclusion that the classification.
Yes. Yes, Mr. Attorney, I got your note, yes.
Along with a note, we have a letter.
It is true.
The letter received from the ministry, which is, I place it on record, 15th April, which outlines in seriatim the proposed amendment. In fact, after I looked into it, I thought of a few more.
But therefore, like us to now hear the matter at this stage or defer the matter for the and the proposed amendments also you have referred to.
It contains one in the letter from the ministry which contains the detailed
yes.
set of amendments, and along with it, the approved draft language. But that's only for placing the matter before Lordship. But a few more things that came to my mind yesterday.
The amendments that are proposed is to categorize the transport and the non-transport category within the bracket of LMB license, light motor vehicle license.
In National Insurance Company, category of vehicle and type of vehicle said it does not make a difference. That's why the endorsement was not required there. So I thought we should take care of that question. A few more things I think, after read that.
We know that election is on, but you see, we had indicated that we'd like to see the light of whatever the proposed amendment. Any timeline in your...
Only after the election. The consultation process is almost over. It has to go to a cabinet committee and all that. Then I think it will be through. And then after I got that, I had a few more suggestions. I thought I'll share it to the ministry.
For the purposes of this case, my lord, it may not make any difference because, as your lordship had seen, if I'm right in, my lord, what I had contended last time, that section 3, that proviso says that provided if you want to drive a transport vehicle, your license must specifically authorize you to do so. Therefore, the license should have had an endorsement that that your LMV license, you are authorized to drive a transport vehicle also. Now, my lord, they have made this only clearer. But they have not changed it. They have not said that you don't need an endorsement.
But then on the other hand, once the amendment will come, we will see what is the impact of this. Possibly
just have a look
at a few more things. I looked into it. I'm alive to that.
Just have a look at the proposed section 10. Just have a look at the proposed section 10, my lord. That's on the second page of that proposed amendment.
Yes.
Starts on the second page, and if your lordship has 10.2, which is on the third page. A learner's license. Does your lordship have that, my lord?
Yes.
A learner's license or a driving license, as the case may be, shall also be expressed as entitling the holder to drive a motor vehicle specified as transport vehicle or non-transport vehicle with manual gear selection or automatic gear selection, as the case may be, of one or more of the following classes, namely, and C is light motor vehicle category 1. So what they've done is they've divided light motor vehicle, which was up to 7,000 kilos, into two categories.
LMV1 and LMV2.
That's right. But they have also made it clearer than before. Earlier, my lord, one had to look at 3 proviso, etc. Now they've made it very clear that your license will indicate whether it's to drive a transport vehicle or a non-transport vehicle. So therefore, the same position as was there earlier, they're only making it clearer. So therefore, I'm not, in my humble submission, need not await.
In 10.1, every learner says so-and-so shall be in such form, shall contain such information endorsed in such manner, prescribed as so-and-so. Therefore, the rules will certainly take care of all of that.
What we'll do is let them, since they are now proposing to bring about an amendment to the MV Act, let them go ahead with this process. And what we could do is we'll keep it, because, otherwise if we deliver judgment before the amendment, then what is the impact of the amendment on the judgment of the Constitution bench will again be a moot question. Instead of that, we can have the amendment, see what, if you are right, that the amendment in fact makes things, the position which you are espousing clearer.
Yes.
Then so much the better. Then we can always say that. We can deal with the amendment which has been brought
I have
forward
no
by
difficulty with that, Lord. The only issue is how long they'll take, because since your Lordship had heard this matter substantially, therefore, Lord.
We take it in, say, the second week of July?
No, I think the sessions may be only after. Let it be in the last week of July. It'll have little time to push through, because I know what kind of agendas the Parliament will have immediately. Many pending agendas are there. I won't be able to say anything now.
My Lord, if I may suggest.
There's one more.
Sir, Attorney General, one more thing. When Parliament brings about the amendment, you'll also have to see what happens to those people who held licenses in the past. Will we require a sunset clause?
I've asked the minister to take care of that so that we provide for a transition, and that there's no gap in the, as far as
Exactly. There'll have to be some provision for a transition.
There are certain things, Malaj, we want to propose. Malaj, can we also be consulted? Because while the consultations.
They can all give.
You can give whatever you want to the ministry. The consultation process is complete, but that you can always give what you want.
My Lord,
So,
just one thing. What fell from my Lord during the hearing was, my Lord won't be changing anything retrospectively, because my Lord, appeals are pending, everyone has got compensation. What will be done would be prospective. Even if the amendment comes, it will be prospective. So there's no point keeping this present petition unless my Lord is inclined to change it from 91 and give an interpretation.
let's keep it where it is right now. Whether it is prospective, retrospective, we needn't anticipate what Parliament will do.
No, my Lord, even if they bring it or change it, doesn't change it, it will be all prospective.
We don't know. Parliament has the power to do what it to legislate retrospectively.
We'll deal with that today, my Lord. The question is what transpired from 91 till now. My Lord, what fell from my Lord is my Lord would not give an interpretation which would change things retrospectively.
Why are you insisting on that? I mean, elaborate arguments, I think all the pros and cons have been discussed in course of the deliberations, and the government is proposing to take a call by virtue of the amendment. Whether the amendment will apply retrospectively, I'm sure they will have this thing. The Chief Justice has already indicated that there will have to be a sunset clause as well. So therefore, I don't think the submission that you are making has any bearing on the matter. You want us to write us the judgment?
Lordship has already protected
for the
the interim order. Our interests are protected. That will continue.
In pursuant to the order dated 22 November 2023, the Union Ministry of Roads, Transport and Highways has carried out an exercise of consultations which the Learned Attorney General has submitted a note indicating that the consultations carried out by the ministry have culminated in certain proposals for amending the Motor Vehicles Act 1988. By its communication dated 15 April 2024, the ministry has placed on the record details of the proposed amendments to the statute. In view of the impending general elections, the Learned Attorney General for India requests that these proceedings may be deferred until the last week of July 2024, so as to enable the Union government to bring forth proposals for the amendment of the Motor Vehicles Act 1888 before the newly constituted Parliament following the general elections. the impact, if any, of the amendment which is proposed on the reference is, of course, will be decided in the course of the hearing. Full stop. In view of the above position, we stand over the hearing of the reference to the Constitution bench to 30 July 2024. That will be
Just one thing, Lord.
For the consultation, we are allowed to, because it will only make the process.
See, we don't have to say it's a parliamentary process, so we can't say that you shall be consulted. They will always do it. You submit your representation to MORTH.
Lordship,
Just one thing.
to reiterate,
And my lords, if it's recorded.
Already completed that. They've already carried out extensive consultation. If you are so interested, you should have made your representation. Anyway, we'll not say anything. You can always submit
Just
your
one,
representation.
just one.
reiterate, Lord, what the para 5 of the order of 22nd 11/2023 in this very matter. Lord, I'll just read that order where Lordship has given us the protection. It says that, during the pendency of this reference, the judgment of the 3-judge bench
Yes, that's right.
Devangan shall continue to hold the field. That's all, Lord.
So we have said that it's not until today. That is already clarified on that order.
Just one thing, Lord. In the last order, what your Lordship had said was, it is understood that in the event that the issue is not resolved by that date by the Union government, the proceedings shall be listed for concluding the remaining part of the hearing on 23rd April.
But now that they have virtually formalized the amendment.
I know. So all I'm saying is, would your Lordship only add this? Because if they don't do it by the next date, because Lord, at some stage.
If it doesn't conclude, if the government comes to the conclusion that you don't want to bring an amendment, then we'll then.
I think even prior to the set date of hearing, I'll be able to come back to the court and inform the court in advance. And the progress will certainly be intimated to the court.
All right. Now, thank you.
Lordship, yes.
You also have shared a note to the court.
Now, what do we do in this case? Because the committee has submitted its report. The government says that, because of the impending elections, we have not been able to take a final conclusion. Now, you have said that on a prima facie consideration of the report and points of view that may be presented to the court in this regard, this court may proceed to hear the matter or await the final outcomes on the consultative process and the views of the government emanating therefrom. So what would you, should we list it then for hearing and...
Please, I think.
Either way.
Because
My lords, we
as
would
far
say-
as- Yes.
Our request is your lordship should, because the government has not accepted the report and it's still being deliberated at the interministerial level. So if this process goes on, it'll go on for 6 months.
So what we can do is we are now on the 16th of April. We have basically 1, 2 and 3 weeks now. This matter take to argue?
My lord, the written submissions have come in on both sides. I think mainly it is for the government and them to argue. My lord, on our side, I think there are only 2 of us. So we will not do that. The issue will be, my lords, really the 4 judgments of your lordships now in TRF, Perkins and Tantia on one side and Core on the other. That's really the...
There are some few other judgments also, Madam.
That's true. That's
There are
true.
few
That's-
judgments also.
That's right.
In fact, there are multiple facets which will have to be considered.
2 days should be enough.
I know.
There are some few other judgments also, Madam.
That's true. That's
There are
true.
few
That's-
judgments also.
That's right.
In fact, there are multiple facets which will have to be considered.
2 days should be enough.
I know.
One more request, my lords. I had moved an application for de-tagging of my petition, but we are withdrawing that application for de-tagging, my lords. That's 12005.
I only spent some time whether to be de-tagged or not. Now they're withdrawing. I withdraw my time spent on that.
In view of the note which has been submitted by the Learned Attorney General, it has been agreed on behalf of all the counsel appearing on behalf of the contesting parties that the proceedings may be now listed for final hearing. The reference to the Constitution bench. The proceedings shall be listed on 30th. We'll keep it on the 30th itself.
It may go on for a second day.
For a second day. So 30th, 31st, we'll wrap it up.
Yes. And my lords, I may be permitted to withdraw.
There are some people who believe it will take 3 days.
No, we'll finish it in 2 days. I mean, I don't think this reference will take longer than that. There's so many judgments now which hold the field from Perkins onwards.
What are the IAs,
Mr. Yeknal?
I have an IA for one of the questions of law. Pertaining to Perkins' judgment, that all unilateral arbitration agreements stand structured as per Perkins.
That we'll have to decide. We will hear everybody. No difficulty.
And your lordships are permitting us to withdraw the application, my lords? 12052?
Nodal Council has still not filed the submissions as
There are
yet.
other things that have kept coming in a lot of time. So therefore, Lord, even the dates, I was going to make a request.
Yeah,
for dates also.
the written submissions and compilations in terms of the circular dated, now to the date of the circular, 3 April 2024, shall be filed by the Nodal Council no later than by, we'll say,
Week of July.
we'll say by the 15th of July.
Yes.
And yes, all parties seeking to file any submissions shall ensure that they are forwarded to the Nodal Council on or before 11 July 2024. So you have 4 days. Then you have to just collate it and put it in a proper.
Already mostly done.
Mostly done.
Mostly it's
We have
done,
already
yeah.
filed our.
Okay. Make sure that they are emailed to the court master so that.
Yes, yes, you know.
अच्छा जरा सा एक काम कर दो, इसे मेरी अनुष्का से बात करा दो जरा।
Yes.
हो गया होगा मतलब।
Namaskar. In this episode of Dil Se, we are going to discuss several issues relating to our criminal jurisprudence. As we all know that the Code of Criminal Procedure and the Indian Penal Code are part of the colonial legacy that we inherited, and we seem to be perpetuating it. And it is having disastrous consequences on the freedoms that we cherish under our Constitution. And I'm going to discuss this and have a conversation about these issues with two of the leading lawyers of our country, perhaps lawyers who have rendered and participated in path-breaking judgments in this country on all aspects of the law. We have Mukul Rohatgi, who has been Additional Solicitor General, Attorney General for India, and in fact led many a battle for people of this country, for the citizens of this country. We have Dr. Singhvi, who is again, some say, a master of the way in which he argues in court. He is a doctor, incisive, always on the point. And of course, Mukul is a doctor in a far more expansive sense. He has doctored many a client and given them the appropriate medicine to get them relief. So let's start the conversation by asking you this question. Are we perpetuating the colonial era and the colonial legacy by allowing the same system of legal of what is the Code of Criminal Procedure to continue in the same fashion? What are your views on it, Mukul?
See, there is no doubt that there is some perpetuation of this system because we are still following those laws. And those laws were made at a time when the British ruled this country. There were some good aspects and some bad aspects. One thing which immediately comes to mind, the good aspect, namely that a statement made to a police officer is not admissible in evidence because they did not trust the native police and therefore they made this provision. But the colonial legacy, as you just mentioned a while ago, that you have what is called a police remand. So somebody is under control of the police in a police station or in a police headquarter or a room, whatever, under control of the police, what he has to say, he doesn't say, all that goes on. And what we need is to tune our criminal laws in accord with the basic freedoms of the Constitution, namely Article 14, 19, freedom of speech, freedom to move around, freedom to live, freedom to work, and right to liberty, life, etc. Unfortunately, they have not been so attuned. And I have not as yet seen the new act which has come.
It's much worse.
Sorry. So my view is that there should be a task force which should look at these laws on the touchstone of these 3-4 provisions of the Constitution. And only then will be able to come out.
Let me ask you a follow-up question before I go to Dr.
Yes.
Singhvi. See, our law says that a police officer can arrest a person on suspicion. Now, suspicion is a subjective thing. So you have drastic laws like UAPA, you have drastic laws like PMLA, and you can arrest a person on suspicion and nobody can challenge it. This very process of arresting somebody on suspicion without fully investigating the matter
so again
is a very dangerous thing.
Yes, so I come back to this. If you look at those laws in the light of the constitutional freedoms, you need to tweak those laws. You tweak it in the light of the Constitution, that you don't give the power of arrest to a junior police officer who will lock you up. And tomorrow if it is found that there are no real grounds, in our courts, there is no compensation for vexatious arrests. They, well, I thought he was guilty, I've arrested, that's the end of the matter. So you must tune it in that, and even if you have some drastic powers because of terrorism and stuff like that, give it not merely to a senior police officer, that by itself hasn't worked. It hasn't worked.
Yeah.
So you must have some checks that it must go through 2 or 3 levels of senior officers who should on the file order that yes, not 1 but 2 or 3 have seen the basic facts and we feel that an arrest is made out. Unless it's a case of somebody committing a crime in your...
That's different.
Before your eyes, like somebody committing a murder.
Right.
If you have these things, and you have those checks, again you look at the touchstone of the Constitution, maybe we can come on.
Kapil, actually you raised a very important question, and I think it is far more than mere, changes. I think it either needs fundamental legislative restructuring. And along with that, I think it needs a complete change of mindset of the judiciary also. Both have contributed to a degradation and decay of the criminal system, where the constitutional values we are talking about. We've got these grand articles 21, 20, etc. in the Constitution. Now, what's the reality? Let me give you a very telling example. Take bail. Now, bail in the most serious offenses everywhere in the world, you get bail. Leave aside a few categories of terrorism or child molestation, etc. You get bail. The classic and the only test for bail is that you have a presumption of innocence. And the presumption of innocence can be only effectuated by giving you bail, but putting you on conditions. And it is what we call the famous triple test. You will not interfere with witnesses, you will cooperate, you will not flee, and there is no flight risk. But that is actually in practice, and I'm now talking to the judiciary, turned on its head by adding a 4th test, which has no place, according to me, if you marry the principle of presumption of innocence and freedom. That is, कि हाँ भाई, इनको flight risk भी नहीं है, ये cooperate भी करेंगे, ये पेश भी होंगे, लेकिन gravity of the offence. I have for long believed that I must argue a matter where this gravity of the offence must be investigated. What is the question of gravity of offence? You're not convicting me. You're not trying me. You are giving some subjective view of the gravity of the offence. The whole point of bail is that till you convict or acquit me on the gravity of the offence, you give me bail. So the point I'm making is assume all the three tests are in my favor. I have roots, I can't flee, I'm going to come every day to the police station. Still, bail is denied regularly on gravity.
It's the norm.
So this is turning the jurisprudence of bail on its head. Second example, this fact of creating more and more laws with skewed and special provisions for bail. I mean, Section 45 and all this of the PMLA or the UAPA is only some example. Point is, these provisions, and this is where I fault the judiciary, have to be consistently interpreted by the apex court to give us clear direction and momentum. What happens is today, this judge interprets it in the right way. But then there is some inconsistency. I speak in a different voice. So there is chaos. These provisions have to be interpreted very strictly. Many of them actually have to be interpreted on the constitutional anvil. And I would say the best example is Nikesh Tarachand Shah very, very minutely examined the constitutional validity of that 45 provision of the PMLA, which is draconian, and said it's not constitutional in many ways, but yet our own courts have then held it differently. The point is, if you lean in favor of freedom, then, and otherwise you can't do it, then you have to have legislative intervention. That I don't think is going to happen easily. So at least within the interstices, you can interpret it correctly.
I was going to come to bail a little later.
Can I just add one thing, sir? He mentioned about gravity, cooperation. Now, I have a serious problem with the phrase cooperation. If I am an accused, I have a right of silence. That right is under the Constitution. Nobody can force me to speak. What do you mean by cooperation? Does
Cooperation means you must say what the police wants you to say.
Well, does it mean that I admit the offence? What else is cooperation?
Right.
See, I can understand cooperation in a case where somebody is accused of murder. Murder weapon is not found. So you say, yeah, tell us where the weapon is. So under section 27, it will lead to the discovery of the weapon.
Right.
That is admissible, not a statement. I can understand.
Correct.
But in any other economic offence, so-called, you first say that we turn the innocence on its head by saying that we will believe that you are not innocent. That's the first thing.
That's right.
That's the first error in these laws. The second is cooperation. Every judge writes like a mantra. You will cooperate, you will not tamper with the witnesses. Tamper, yes. But when you say you will cooperate, what does it mean?
No, it is worse, Mukul. There are judgments which say cooperation does not mean confession. Cooperation does not mean you will say what you will say. But that judgment comes and then there is a dissonant voice after a short while.
What does it mean? Every judge says cooperation.
So it has to be consistently applied.
That's right. I mean, we're talking about bail provisions. Actually, I was wanting to take the conversation back to prior to bail, the custody by the police.
Right.
I think bail comes later, custody comes first. So what are the parameters for custody is the question I started with. You went on to bail, but we'll deal with that a little later. So what are our thoughts on that?
It's very important. We have stopped for many decades making a distinction, Kapil, between power of arrest and need for arrest. This is a fundamental fallacy. I have a power of arrest. I equate it to the need for arrest. Today, according to me, forget the fact that you are filling up your jails with unnecessary occupants. Forget the fact that you are doing it politically motivated in many cases. Forget the way that you are harassing. The fact of the matter is that I would say more than 90% of arrests would not be justified if you made the difference between the need for arrest and the power of arrest.
Correct.
All the
so
arrests,
what do you need to do to justify that need for arrest is the question.
See, there are two things. Ideally, there should be a filter required by legislation. You can say you will first record these. It will then go that stage. When two people have recorded, then you can arrest. That is one. But that's never going to happen. Unfortunately, it is not easily going to happen. Whoever is in power, you tend to go with the power. It is for the courts to start reading it like that. But again, consistently 5 Supreme Court judgments the same line, then the law will be laid down. You have to say that, what is the point of arrest? You are arresting people, Kapil, in most cases we are all doing, after 2 years, after 3 years. Anything you wanted to collect is there. Papers have been collected, raids have been done, statements have been recorded. What is the need for arrest?
You are also arresting people without any evidence at all.
That's the other category.
It's a far more serious issue, because now if you target individuals who you're politically against and you arrest them without any evidence, and then no bail is granted because there is a suspicion that they have committed the crime, where do we go from there? And if you add 120B, which is what is conspiracy, he's not directly involved in any offense, you will say 120B, conspiracy. Now you can't prove conspiracy. There is no basis for proving conspiracy, but you will keep him behind bars. So the issue is, how do you formulate a legal framework within which an arrest must take place? The hierarchy of officers is not going to make a difference, and I agree with you. We need a framework through which arrest can only happen if prima facie it is established that I have committed the offense. Unless you're able to show that to the magistrate, there should be no arrest. I think that's very important.
So the power should be taken away from the echelons of the police.
Yes.
And vested in a magistrate who we still trust, because he's...
And where the evidence will be produced.
And some evidence will be produced. He will have some satisfaction.
Yes.
And he may give you the green light.
Yes. And he will show it to us. That evidence must prima facie be given to us. Okay, this is the basis on which I find prima facie that you are guilty.
But that again, what you are saying is very important, but that will have to be legislative.
I agree. I mean, I'm just saying.
The problem is, I don't know when that will happen. Meanwhile, existing, if the court was to hammer this point every day in the existing law, that you must show a difference between your need to arrest and power to arrest, and we are going to examine it, you'll find a sea change. Unfortunately, courts are not applying that test. They are saying arrest is done.
One more thing, Kapil. 41A was brought in with this kind of concept in mind, that there is some filter.
People listening to you won't know what 41A is.
So there is a section 41A in the Code of Criminal Procedure where the police can give a notice, ask you to appear, and you then interact with the police. And then an arrest may or may not happen. So there is some kind of a filter, some kind of an exercise at least, rather than somebody arresting somebody on mere suspicion.
But it's not followed. No?
So the problem is, there is a direct judgment of the Supreme Court on 41A. We call it the Bible. It's called Arnesh Kumar.
That's correct.
But whatever Kumar it is, it's never been followed.
Yes.
In rare cases, I come across orders where it has been followed. In rare cases, we come across courts holding the arrest to be illegal. If there are 100 arrests in India today, probably one may be held to be illegal on certain facts, but it is kind of given. So probably, I would tend to agree with you, take away that power from the echelons of the police and vest it in somebody.
Right.
And if you don't want to vest it in, let's say the magistrate, because every day they are also overworked. You can think of a body like the CVC. The Vigilance Commission is generally a good body. People don't, make allegations against it. So give it that kind of a power, that kind of a level of a person, and you can grade it. If you're talking about an offense of 7 years, arrest in a 7-year offense or a 10-year or 15-year, you can grade it and then give that power to those kind of somewhat neutral authorities. You can say, look at the file and say, well, I feel it's okay, I don't feel it's okay. Maybe that would be a filter.
Well, the problem is the following. If the police officer assumes that you or suspects that you have committed the offense and there are no parameters at all, there is no way to actually test that. Article 21 says life and liberty, protect life and liberty and arrest a man in accordance with procedure established by law. What is that law? Suspicion. It is inconsistent with 21 itself. How do you correlate suspicion with Article 21?
And let's face it, this is a huge reservoir of power which is abused, which you are giving to police officers.
Daily abused.
And we also must understand, and it's no criticism to say that the manpower which is there in a Western country from where we pick up some of these laws, and the manpower working under such pressures and conditions here is totally different. It's so easy to abuse that power here. And the checks and controls
in other jurisdictions.
I would say, Kapil, put it down on paper.
Yes.
The moment you put it down on paper, there is something to test it with.
Exactly.
Even if it is 5 lines.
I agree.
7 lines, 10 lines.
Exactly.
And somebody looking at it, say, well, you are not on an unruly horse. He has done something. There is some material. Yes or no.
Under the present law, when a police officer arrests you on suspicion, he can keep you in his personal custody, that is what is called police custody, for 14 days. Now, under some special statutes and under the new framework of the Nyaya Sanhita, you can be kept in police custody up to 90 days. Now, that's much worse than the colonial era. Now, that means a man or anybody arrested will never get bail for 90 days because the investigation is going on. So we are moving to a much worse regime than we inherited from the colonial era. So I think the Supreme Court should be cognizant of these things.
So, Kapil, I would say that what we call remand to the police or police remand is premised on the sanction of the magistrate.
Right.
So you have to be produced within 24 hours of arrest before a magistrate under the mandate of the Constitution. The magistrate has to authorize remand, whether it's up to 14 days or any number of days, he has to authorize.
Right.
So he has to apply his mind. Say, yes, should it be done, should not be. Unfortunately, I would say that maybe in 1 out of probably 50,000 cases, a magistrate would say that not even 1 day remand is necessary. I have not come across.
Never. You would never.
Very,
get it.
very
Yeah.
rarely
Yes,
you will come across a case. The last case which comes to mind was Mrs. Gandhi's case, where the magistrate said that there is no material to remand and she was released some 40 years ago. So it is, law does provide for a check, but that check has become ineffective because the remands have become
routine,
mechanical.
Yes.
The magistrate does pass an order, but he's doing lip service. Say, well, they say that we have to do this, we have to examine, he has to cooperate, he has to tell us this, that. Okay, so
we've seen the case diary and on the basis
and case
of
diary,
that.
case diary is something which the accused can't see.
That's correct.
That is another.
So what is the solution? You have a law being passed like that.
Right.
Instead of a law liberalizing it, it's a retrograde law.
Yes.
So the only way out is, we are talking of legislation to improve.
Yes.
Here you have a legislation in the other direction.
Yes.
The only way would be the courts have to be robust to strike it down.
Right.
This will have to be hit by some 21, some 20.
But you look at it this way. Look at your PMLA, talk of bail, and read the provision for viewers. You will not get bail unless the public prosecutor has been given an opportunity to oppose the application for its release. And when the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of the offense. Now you tell me, the accused doesn't know what's against him. I am arrested on suspicion. I am produced before the magistrate. I have no material with me. How do I convince the magistrate that I'm not guilty, or how does the magistrate come to the conclusion that I'm guilty?
Kapil, on the bare text, this is an impossible provision.
Should have been struck down.
No, it was struck down.
I know, but it should be struck down again.
No, but the whole story doesn't end there. On its text, this is an impossible standard to satisfy.
Yes.
It was rightly struck down in a very well-reasoned judgment by an
Justice
outstanding
Nariman.
jurist.
Yes.
But the amendment is very interesting, by which they're supposed to have restored it. According to me, those 3 words added do not at all restore it. What happens? After that, in the period after a judgment called Nikesh Tarachand Shah for your viewers, which struck it down, and till the amendment came, or even after that, even after the amendment, most of the high courts took a robust view. They said this does not mean that I must find him not guilty by a certification now. It cannot mean that. Therefore, we'll take broadly the same view. Then along came the judgment of the Supreme Court, which we are now trying to review. And therefore, that judgment really put the seal on what a robust view the high courts were taking, despite all this.
My fundamental objection to all this is contrary to our basic freedoms. And why should the court tolerate such legislative measures which destroys the very fundamentals of of the rights given to us under the Constitution? Now, if you look at the PMLA now, and the viewers will understand, you have a 420 offense which is cheating under the penal code. Now, if it is put in the schedule of the PMLA, it is 420 again. Under ordinary law, you will entitled to bail. If it's under PMLA,
no bail.
You will have to show that you're not guilty of
45.
the offense. What kind of law is this? And why is the Supreme Court not looking at these laws? That's the next question I have. These kind of laws and these kind of prosecutions are irreversible unless you hear the matter immediately. This matter, PMLA, has been pending now for months.
In fact, I was very sorry, you and I were in that matter. the reconsideration of the main controlling judgment in PMLA, which we believe, and I'm openly saying that we don't believe is right at all, Vijay Madan Lal Chaudhary judgment. One full day you argued, one full day I argued. I'm ashamed to say that every attempt was made by the government to make sure the matter is not heard. Now that is the review, that without that obstacle being clear, I'm not saying that you have to win it or you have to lose it. It should be referred for reference.
The issue is, this matter should have been heard much earlier. What are your views on it, Mukul?
No, see, cases which involve liberty of hundreds and thousands obviously should get a priority and they should be heard. And according to me, not only this case, but there are several other cases. I mean, let's put it this way, to every individual, his case is important.
Yes.
To every individual, you know, he has his case to be heard. We have, unfortunately, we are into a big clog. You know, there's a clog of cases, there's the courts are full of cases.
Mostly corporate matters relating to corporate disputes.
My feeling is that unless we drastically amend the system of hearing of cases in courts, this problem will remain. I mean, you may aggravate it or you may bring it down.
What do you mean by amend the system? Let me sort of ask you.
What I mean is that the whole system is skewed.
What is that? I mean, what? Let's come to specifics.
Yes. Let's start with the Supreme Court.
Yeah.
The Supreme Court was formed in 1950 to hear a particular class of cases involving the Constitution or very, very important questions of law, of liberty, of freedom of press, of things like that. The Supreme Court itself, after 20 or 30 years, I would say, or after 20 odd years, it forgot. The Supreme Court has forgotten why it was established. It has today become nothing and nothing more than a regular court of appeal. Every day we do hundreds of cases in the Supreme Court. They are mundane cases. They should never have gone even to the High Court, much less the Supreme Court. Every bail goes to the Supreme Court. Every injunction goes to the Supreme Court. Unless you set that house in order. So you first set the Supreme Court in order, but you must have, you must revisit. The court must revisit what it was meant to do and what it is doing. That will then percolate to the High Court. The High Court will say what it is supposed to do. Unless you do all that.
But I am on another question. You're right. I mean, you're talking about large structural change.
Yeah, absolutely.
I'm on another issue. There are cases which are of seminal importance where the liberties of our people, right? Those cases are not being heard for years, right? There are other matters that are being heard in priority. The question is, who decides the priority? Should the priority not be decided in the context of the damage it is causing to people whose freedoms are being taken away? Now, that should get priority, no? That is not in the hands of the system. That's in the hands of judges themselves.
And the best example of what you're saying is your recent judgment of electoral bonds.
Yes.
What happens is that the system ultimately reaches the matter and possibly gives the right result as it gave with the electoral bonds. But the damage is done completely.
Exactly.
A former Chief Justice has repeatedly in my presence said that we'll hear it next week, next month. That next month, next week in 2019 became 2024.
So the problem is in the PMLA, for example, if after say 6 months, 1 year, some of these provisions are declared to be unconstitutional.
Then what happens?
Then what happens?
For example, all the benefit of the electoral bond was gorged.
You mentioned electoral bonds. I would still like to add, yes, it is important. It is more important for political people. An individual who's looking for bail or
I agree.
His roti or makan, you don't bother about electoral bond.
Yes.
Both of you are politicians, so it's important.
I didn't say that.
That's my thought. But as a pure practitioner of the law, what is more important by far is affecting liberty of hundreds of people.
This is what my
undoubtedly.
Yes.
I mean, I would rather say this should be heard.
Yes.
I don't give a damn about electoral bonds, whether 5,000 to BJP or not. The general public is not concerned.
No. We'll leave that out. That's controversial.
My point is different.
But freedoms are far more
important than all
My
others.
point is a little different, that the time taken to give the right verdict, the benefit of the wrong is already absorbed.
Yes.
That's the point.
That's the point.
Electoral
I agree
or
with
liberty.
you. But then
whatever damage has to be done is done.
But then it's happening everywhere. A small individual, he gets acquitted after 8 years. He has served the sentence. He has served
That's
everything.
another sad part.
उसको देखो, उसका क्या हो रहा है?
I agree with that.
But
You
they
have
should
to.
decide these larger issues of law which will affect not individual, but
Therefore,
affect the whole batch of
PMLA,
cases.
according to me,
PMLA.
is the prime case which should be heard at the earliest for these kind of provisions, and as to whether it has been rightly passed as a law or not, which hits at the root.
That's right. And it should be heard, according to me, by 5 judges, so that it settles the law. 5 senior most judges should sit
According
and
to
settle
me,
the law.
Kapil, the judgment which was delivered, which is the bane of all these problems, by a 3-judge bench, that's the procedure was wrong by saying, I will decide on the validity, but I will not decide whether it was rightly born under the money bill or
That's
not.
correct.
You cannot separate. If you find you have upheld the law, people are in jail. They can't get bail for 5 years,
Correct.
4 years. After 3 years, suppose it is held that it was wrongly passed by Parliament, it could not have been done.
Correct.
How will everything else be undone?
Absolutely.
You can't leave that challenge separately. That should have been the first decision.
Absolutely.
Rather than 3 straight away, 5 or 7 judges. Is this law born correctly?
But assuming you're right, this court can easily hear the matter
Yes.
on the issue of money bill.
Yes.
It has been pending for long. Why shouldn't it hear it? That should have priority, especially in the
Yes.
context of freedoms.
According to me, that should be heard first.
Yes.
And then you
Threshold
issue a
question.
review of the judgment.
These are very important things.
I think they realize it, but it's just not happening because the threshold question will affect so many sectors, not
And
only
it'll be
PMLA.
irreversible. After a while, it'll be irreversible. Now, the next big issue I want to discuss with you, we have had a fascinating discussion, is about conspiracy, 120B. Now, in every offense where you do not have direct evidence against an individual, you add 120B. Now, that man will never get bail. There is no proof of conspiracy till the end of the trial. Now, what happens to that category of cases and those accused who are involved in the 120B? Should 120B be used in this fashion under a criminal
That's the point.
jurisprudence?
First of all, it has been around, but the misuse and the use in which it is done now was not being done earlier. That's the tragedy. Even with similar provisions, you are really misusing it now. Number 2, in every case, I'm finding an argument which is completely used not to be raised earlier, that 120B is a standalone. 120B, the tail will wag the dog. It will stand alone. Now, there is fortunately, and these are the kind of things which are required, judgment which says that you cannot have a 120B alone under, for example, the PMLA. It's a very robust judgment. But even today, as of yesterday or day before, the argument is still continuing. It is justified. It is not, there are any number of cases I'm doing where 120B as a standalone is justified. After a judgment, there has to be also, I think, somewhere a sense of responsibility by the people who still propound an individual case that, look, this is now covered, that should go.
You forget PMLA, 120B used in every
Even in
criminal
every
offense
other
to
case
get-
also.
To get involved, to get people as accused, who they want.
I really hope that judgments like this are also made in the other non-PMLA category and they are consistent. My fear is always that you make the right thing and then somebody changes the law in another judgment shortly.
Again, in 120B, there should be some legal parameters on the basis of which you can involve somebody in conspiracy. What are your thoughts on that?
My thoughts are on your last comment. See, one thing is to lament that the court is doing this, court is not doing it. That's one issue.
Yes.
I mean, there's no point of lamenting beyond a point. You have to bring a structural change in 120B.
Yes.
It's a 150-year-old law.
Correct.
It is being used or misused or whatever. Just as we were discussing that the power of arrest custody should be with a body apart from the police, some structural change should be brought in that provision
Exactly.
because it's a all-encompassing provision.
Exactly.
120B,
Yeah.
conspiracy, small conspiracy, big conspiracy, larger conspiracy,
Correct.
all these things are developed.
Exactly.
So you put in something in 120B, and if the legislature doesn't do it, the court should step in
Yes.
to say that the rigors of 120B will be tested on these
parameters.
कि भाई some prima facie material कि तुम उनसे मिले हुए थे
Correct.
in some form or the other.
Correct.
And the classic test is a Privy Council test where some people robbed a bank. One guy was waiting in the car, the getaway car. He argued that, look, I didn't do the robbery, I was only driving the car. So they said, no, you are a part of the scheme and you were looking कि police na aa jaye, and therefore you will be a part of conspiracy because you were in the scheme. The cases you were talking about, nobody, this man doesn't know what is going on there.
Exactly.
So unless there is some structuring, it was said by Privy Council 100 years ago. So you structure that through the court. It won't happen through Parliament. Structure it through the court. Take out the Privy Council judgment. Put your own imprimatur in whichever manner you want into it.
Mukul, I have seen cases कि किसी ने speech दी मुंबई में and some violence took place in Delhi. They will say, but he was the linchpin, the man who gave the speech in Mumbai, and he'll be involved in conspiracy. Well, I've seen this happening. And people are in jail for 3 years, 4 years for this kind of stuff. But this is a very serious issue. And the problem then, and the last issue, before we close this wonderful discussion, is that why does the trial court never grant bail to anybody? But this is a very serious issue. As a matter of course, no magistrate will grant bail. In the rare case, maybe.
I'll tell you, Kapil,
this is a very serious issue.
Our experience shows that when we started practice, the High Court used to write a 5-line order and grant bail. Hearing would last 5 to 10 minutes.
That's right.
As things progressed, these laws became more complicated. And unfortunately, the Supreme Court, which was supposed to be the beacon of these freedoms, despite saying bail is the rule, not jail, etc. The Supreme Court, I am sorry to say, has become small-minded. A large number of bail orders are today interfered with.
Yes.
Which was never the job of the Supreme Court even 25 years ago.
That's correct.
Every second bail order is interfered with. A grant of bail is stayed by the court.
That's correct.
That you remain in jail.
Yeah.
Normally, if you have bail, it can never be stayed.
Absolutely.
You can cancel it in egregious cases, but you never stay.
Absolutely.
But since that is now happening in a mundane fashion, routine fashion, that also filters down.
That's right.
I mean, High Court judges also say, if we grant bail, next day it is stayed, comments are made, why have you granted bail? So it filters down, वहाँ bail नहीं मिलेगी, वहाँ cancel होगी, तो हम भी नहीं देंगे. But remarks are made, अरे सब Supreme Court चले जाइए.
The mindset of the magistrate is कि भाई हम तो नहीं देंगे, आप High Court से ले आइए.
अब ये mindset High Court में भी है.
It's a very strange.
High Court कहता है कि ये हम नहीं देंगे, आप Supreme Court से ले आइए.
ये सारा ऊपर से filter होता है.
It's a strange amalgam, Kapil. I think there is also a feeling being generated. अगर इसने bail दी है, तो सब कुछ दाल में काला है. वो दाल में काला theory goes there to the High Court. हम अपने ऊपर क्यों ले? Let the Supreme Court. That is one part. There is another part for special categories, and this is, I think, important in practical terms. For special categories, you have special judges. Now, it's okay. Special judges is valid. You must have special judges. You must fast track certain categories. But why should you have the same human being as special judge for years? Whether it
because
is
he's special.
MP, MLA courts.
Special human being.
By MP, MLA court, you certainly have. But we are now finding a chain where trial judges are lasting 2 years.
Yeah.
There's no problem. Nobody is asking for a particular judge. You rotate the judges every 3 months. High court judges in that category are lasting 2 or 3 years. The net result is a chain of command is made straight away, where the result is virtually, known because the particular, I'm not saying anything bona fide or not, but it could be bona fide. But my predilection, even bona fide, makes a consistency of negativity right up to the Supreme Court.
That's right.
आपने mindset की बात करी. Till recently or even now people used to say, कि भाई bureaucracy का mindset कैसा है? कागजी कार्रवाई करते जाओ, decision मत लो. और ऊपर लिख दो submitted please.
That's correct.
तो फिर ऊपर गया, उसने कुछ लिखा, फिर उसने लिखा submitted please.
That's correct.
तो इस तरह जो चल रहा है, वो ही यहाँ आ गया है. Submitted please, आप वहाँ चले जाओ. वो कह रहा है, आप वहाँ चले जाओ. और ऊपर mindset अगर वो वैसा नहीं है, तो this is actually.
Well, all that I can say is that we've touched the tip of the iceberg.
Absolutely.
There are so many very serious issues that bedevil the functioning of the criminal justice system. But thank you very much for being here, because this will, I hope people who listen to this understand, because we are here not for any personal issues. We are here for the larger interests of the country in the context of the freedoms that we cherish. And I hope that we are going to meet in future and have some in-depth discussion on many of these issues.
Thank you very much.
Thank you, sir. Thank you very much.
Good morning, everyone. Before we start this seminar, on the passing of senior advocate and eminent jurist, the Fali Nariman, we'd like to pay a short tribute to him. I'd like to invite Mr. Vipul Mudgal, Director of Common Cause, to please pay that tribute.
Thank you, Cheryl. Privilege to start this great event today. Dignitaries on the dais. I've been asked to represent the civil society because there are lots of lawyers who speak from personal experience and who talk about Fali Nariman, his times, and who've seen him in the courtroom. But I've seen him only as a civil society activist, and I don't have any personal experience, I must say. So I don't have any personal insights to offer. Dignitaries on the dais would definitely know much more, and all of you, etc. So I can say that the civil society, generations of civil society before me and after me have deeply respected him for what he was, for what he stood for. At one meeting, he said, this was a memorial meeting for somebody, that he was a good man. And you know what, good men who do good things. And I thought Nariman was a good man and he did good things, and that is why civil society remembers him. He was, as an author, for instance, I mean, his books, which were not law books, will be very soon classics of legal text, because he was a good man, because he did things, he represented values which we all believe in. So, as an author, he's a chronicler of our times. As a public spirited citizen, that comes much before being a lawyer and being a jurist. So civil society will always remember him as someone who took up vital public causes, and he fought for constitutional values and human dignity. And by civil society, I don't mean a narrow kind of definition of NGOs or charitable organizations, but I mean civil society in a broad, pluralistic kind of sense, where all types of citizen groups, associations, and diverse voices of victims, vulnerable sections come together. I remember in my organization, Common Cause, approached him a couple of times. We never succeeded, but we discussed cases with him. We sat with him. He gave us insights. But the other organization I represent, Association for Democratic Reforms, succeeded in getting him. Kamini ji is here, she would remember better than me. But at least in one case, where, it was challenged that first ADR went to court saying that all candidates in all elections should be required to do the following: declare their assets, declare their education qualifications. Now, these are very important things, and all of you know why. Their education qualifications.